ready, Mary? Yes. All right, I'm going to call the meeting to order. It's a continuation of our public hearing on a complaint that had been filed by Peggy Adler versus Lisa MacDonald and Cynthia Watts. This is the Board of Ethics, and it is a continuation of the hearing that we had on March 1st last week, and we closed the hearing to additional evidence, and this is continuation for purposes of deliberation and decision on the complaint. Does anyone on the board have anything they want to bring up, or I could start in? No? 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 Okay. Good. All right, well, I have put together a proposed memorandum of decision, and I think what I'm going to do is read it, and then we can discuss it further, and I can entertain any votes or anything along those lines. After a finding of probable cause, a hearing on this matter was held on March 1st, 2012. The board marked and accepted as evidence certain documents and testimony from its confidential investigation, including but not limited to the following: the written complaint filed by the complainant, the written responses filed by the respondent, the sworn testimony of the chairman of the Planning and Zoning Commission, John Main, the sworn testimony of the respondent, Lisa MacDonald, and her husband, Michael MacDonald, the sworn testimony of the respondent, Cynthia Watts, and the record of the Planning and Zoning Commission regarding 2 applications for site plan approval filed by John Watts for a property he owns at 186 East Main Street in Clinton. All the evidence was made available to the respondents prior to the hearing. The respondents failed to appear at the hearing. Their counsel did send to the board correspondence and memoranda which were received and reviewed by the board and noted to be a part of the record. Certain persons who did appear at the hearing were allowed to testify under oath, including other members of the Planning and Zoning Commission, Anselmo Delia and Pamela Fritz. The hearing was then closed to the receipt of evidence and continued to March 6, 2012 for further deliberations and decision by the board. Facts. Without determining the required standard of proof in this matter, the board finds that the following facts are found by clear and convincing evidence. Number 1, on or about October 9, 2009, John Watts, a local attorney and the brother of the respondent, Cynthia Watts, made an application for a site plan approval to the Planning and Zoning Commission with the assistance of Michael MacDonald, a licensed architect and husband of the respondent, Lisa MacDonald, for property Watts owns or has an ownership interest in, known as 186 East Main Street, Clinton, Connecticut, for a 2-phase development of commercial office space. Number 2, both respondents are and at all relevant times were members of the Planning and Zoning Commission, the town authority charged with review of such proposed development projects, and both respondents chose to recuse themselves from the hearings and deliberations on the John Watts application. 3, subsequent to the denial of the commercial site plan application by the Planning and Zoning Commission, John Watts chose to construct the building identified as Phase 1 in the application as a residence. Michael MacDonald assisted him in the construction of that building without the need of approval by Planning and Zoning Commission. Number 4, during the pendency of litigation between John Watts and the Planning and Zoning Commission relating to and or arising out of the denial of the commercial site plan application, the respondents Watts and MacDonald chose to participate in discussions about the pending litigation and ways to settle the pending litigation with John Watts. Number 5, subsequent to the discussions about the litigation, John Watts was invited or advised to resubmit the same site plan application that had been previously rejected by the Planning and Zoning Commission. Number 6, thereafter, the respondents chose to not recuse themselves despite the objections of other members of the Planning and Zoning Commission and both respondents participated in the presentations and deliberations regarding the resubmitted application by John Watts, and both voted in favor of the resubmitted application for site plan approval. Discussion. The respondent, Cynthia Watts, argues that the complaint against her should be dismissed because the mere fact that John Watts is her brother is not enough to prove a conflict of interest. The respondent, Lisa MacDonald, argues that because her husband had been fully paid for his work on the completed Phase 1, and because her husband had no new or proposed contract to work on Phase 2, she no longer had a conflict of interest in discussing, deliberating, and voting on her husband's site plans for the development of the John Watts property. The board does not find the respondents' arguments to be persuasive and accordingly finds that both respondents violated the Town of Clinton's Code of Ethics. Cynthia Watts is the brother of John Watts. She recused herself the first time her brother's application came before the Planning and Zoning Commission, but she claimed that she did so only because the respondent, Lisa MacDonald, told her to recuse herself at that time. She also claims that when her brother resubmitted the site plan application, the attorney for the Planning and Zoning Commission, David Royston, told her that she, quote, did not need to recuse herself from consideration or voting on this pending application, end quote. The board does not find Ms. Watts' claim that Attorney Royston supported her decision to participate in the vote on her brother's application to be credible. The board has admitted into evidence a letter from Attorney Royston dated September 12, 2011, addressed to the chairman of the Planning and Zoning Commission, wherein Attorney Royston clearly finds that Ms. Watts is disqualified under state statutes for participating in the decision on her brother's resubmitted application. Attorney Royston advised the chairman of the Planning and Zoning Commission that there was no authority to force Ms. Watts to recuse herself. Ms. Watts offered no contrary evidence from Attorney Royston. Her hearsay statements about what she believes Mr. Royston said carry no weight with this board. This board finds that irrespective of the requirements of the state statute that governs the disqualification of members of Planning and Zoning Commissions, Cynthia Watts violated the Town of Clinton's Code of Ethics. Section 4A of the Town of Clinton Code of Ethics is intended to prevent the appearance of a conflict of interest when acting in an official capacity on behalf of the town. Voting on her brother's application created an appearance that her independent judgment on the application would be impaired, and she therefore violated Section 4A. Ms. Watts also violated Section 4C of the code because she knowingly and intentionally participated and voted on a matter in which her brother had a financial interest. Approval of a two-phase commercial site plan would likely increase the market value of her brother's property. Ms. Watts further violated Section 4E of the code because she voted on her brother's resubmitted application despite the fact that she had a personal interest in the outcome of the vote. Lisa MacDonald argues that because Phase 1 had been built and her husband had been paid in full for his work prior to her vote on the resubmitted Watts application, she no longer had a conflict of interest in voting on the same plan that had been previously prepared and presented to the Planning and Zoning Commission with assistance from her husband. Ms. MacDonald also argues that Attorney Royston told her that she was not disqualified from voting if her husband no longer had a financial interest in the project. First, the board notes that Ms. MacDonald presented no affidavit or correspondence directly from Attorney Royston to support her claim. The question she apparently posed to Attorney Royston was framed in a leading manner. Ms. MacDonald claims that she told Attorney Royston that her husband no longer had a financial interest in the Watts property, and then asked him whether she could now vote on the Watts application. Regardless of what Attorney Royston may have said in response to Ms. MacDonald's leading question, The board finds this testimony to be hearsay, and it is accorded little weight. Second, although Ms. MacDonald and her husband testified that there is no money due from John Watts, and there is no present agreement or contract with John Watts for additional work, there remains a financial connection between the two men because of the potential claims or liabilities that may arise out of Mr. MacDonald's past work. The board finds that it was always clear to Ms. MacDonald that voting to approve her own husband's work would raise questions regarding her judgment and impartiality. The board appreciates that Ms. MacDonald took the issue of a conflict of interest seriously, and that she did attempt to analyze her personal circumstances and how those circumstances might legally affect a decision by the Planning and Zoning Commission. Nevertheless, the board finds that voting to approve a site plan that her husband helped prepare and present to the Planning and Zoning Commission created an appearance that her independent judgment would be impaired, and she therefore violated Section 4A of the Code of Ethics. Ms. MacDonald also violated Section 4C of the Code because she knowingly and intentionally participated and voted on a matter in which her husband had a financial interest. The financial interests between Mr. MacDonald and John Watts do not necessarily end with the final payment of Mr. MacDonald's invoice. Potential liabilities or claims may arise out of the work performed by Mr. MacDonald on the Watts project for years, regardless of whether Mr. MacDonald intends to perform additional work for John Watts on Phase 2 of the site plan. And finally, the board finds that Ms. MacDonald also violated Section 4E of the Code because she had a personal interest in seeing her husband's work approved and ratified by the Planning and Zoning Commission. So that's my proposed decision. And then depending on what anyone else has to say, we should vote. And I think what we do is, if we find there's a violation, we simply make that finding.
That's the term, in violation?
Yeah.
Well, I think it's, Mr. Chairman, it's extremely well written. It certainly lays out the facts as well as the discussion, and I have no criticism or quarrel with anything that is stated in this document.
It looks like everything is here. I don't think there's anything like possibly left out. It's all been discussed. It's clear to me. And I agree.
I agree.
All right, then I had ended this with wherefore the Board of Ethics finds the respondents breached the trust of the public and Section 4 conflict of interest of the Town of Clinton Code of Ethics by participating in the discussions and vote on the resubmitted John Watts site plan application.
Technicality, do we need to approve our minutes before we move forward on this?
I don't think we do. From the prior? Yeah. We could if you'd like.
I don't know if there's a certain.
Oh, Mary, maybe you can help us.
No.
Since this
I
is
think
not-
we're just
No.
continuing.
I'm just good with that.
Yeah.
Okay.
Do we need to vote on each respondent separately?
We could.
Okay.
Right, you want to do that?
Okay, you want to make a motion with this here?
Okay.
I'd like to make a motion that the Board of Ethics finds that Cindy Watts breached the trust of the public and Section 4, conflict of interest in the Town of Clinton's Code of Ethics by participating in discussions and vote on the resubmitted John Watts site plan application.
Do I have a second?
I second that.
Okay. Any further discussion? Move the question, all in favor?
Aye.
Any opposed? Okay. And with regard regard to Lisa MacDonald.
Wherefore, the Board of Ethics finds that Lisa MacDonald breached the trust of the public on Section 4, Conflict of Interest of the Town of Clinton Code of Ethics by participating in the discussions and vote on the resubmitted John Watts site plan application. I so move.
Second?
Any other discussion? All in favor?
Aye.
And then, I think, just to be clear, we're all good with the memorandum of decision supporting our vote?
We are.
Given all the reasons, Ken.
Excellent.
Round of everyone. All right. Any further business?
May I ask what does this mean? Is this presented to the Board of Selectmen, to the Planning and Zoning Commission? Do we need a further recommendation on this last vote that was taken because the process was compromised and tainted?
The last vote by,
The Planning and
And
Zoning
Zoning
on the
I
Watts
think
property?
that's outside our scope. I do. I think we are charged with just determining whether or not there was a breach of the code of ethics. Planning and zoning, not our authority.
So what they decide to do, it is up to Planning and Zoning, or it's up to the Board of Selectmen or the town attorney?
Well,
I know we're on new ground here.
yeah, I don't think
So
that there's any, I think
Just thought
that
I'd ask.
vote was a vote by planning and zoning. My understanding, there was no appeal taken. I think it's therefore final, and other than that, I don't think I could comment on whether or not anybody can, as far as I know, there was no appeal taken from that vote, so that's outside our scope and authority there.
So who is our appropriate appointing or supervisory authority?
Well, I think we send it to the Board of Selectmen and Planning and Zoning Commission,
Okay.
as well as the complainant and the two respondents.
And then we get, within 30 calendar days, we get a receipt and a ruling as to action taken, if any.
Yes.
Now, there's a process that they could possibly appeal, the respondents.
It looks that way. They could appeal to the Superior Court. So, other than the finding, it doesn't really, the code does not seem to suggest that we can make recommendations regarding sanctions or anything. It does, there is a provision that says findings / sanctions, but, unless somebody wants to raise that as an issue, I'm not.
So within 30 days, the authority that's going to be reporting back to us would be, what would you say, Board of Selectmen, or you can say Planning and Zoning?
Yeah.
Yeah.
We'll refer the matter.
Yeah, I don't know.
What's that, John?
It doesn't, if we're asking us to come up with our own sanctions or recommendations, I think it would be more clear.
Right. I mean, the title says finding / sanctions, but,
I think we are the findings, and I believe the sanctions would come from the authorities we refer to.
Mm-hmm.
okay.
We'll just have to trust that part of the process. Our work is done.
Yeah, I would say so. And I suppose there's nothing stopping us from making recommendations. And if someone wants to,
Nope.
we could do that, or we could, I suppose, bring it up later, in 30 days if we get no response.
So it's not possible to re-vote on the matter. That's what I read in the paper.
Planning and zoning? Yeah,
Yes.
we're not planning and zoning.
Okay.
Whether or not there's some legal mechanism, I'm not prepared to say. I think all we can say is we're dealing with the code of ethics, not planning and zoning statutes.
Right. Well, that would be my recommendation. If we had a chance to pass something tomorrow, that seemed to be the right thing to do.
A new vote?
Yes.
Oh.
As long as we
Well-
can't say it all, then you say if we attach something just for posterity.
Well, I do want to say this, and I agree with what you said, but I would also go along with John on this, that I would recommend to planning and zoning that they revisit this issue, and that this last vote that they had taken on the Watts property would be nulled, and they would look at it and review it again for discussion, because the process really has been compromised. But I'll just leave it at that.
Okay. Yeah, I doubt that is possible.
Okay.
Because there is another party affected, and that party is not a part of this proceeding, so we're just thinking out loud here, but we're not making any comments, or what we say on that has no legal effect. The only legal effect we have is related solely to the code of ethics and not what planning and zoning did or didn't do, or what they could do. So,
Well, we expect some sort of action.
well, we would like some sort of response, I would think. Because, at least from my point of view, the respondents seem to think that what they did was okay, continue to think that. Maybe they will change their position, maybe not, but I think that's all we can do, sort of the parent after the fact.
We've done what our
Right.
mandate is stated
Right.
in code.
All right, so, any further business? All right, and entertain a motion to adjourn.
We adjourn.
Second.
All right, all in favor?
Aye.